So I think let's make a start now. Welcome everyone. Thank you for joining us today. My name is Katie Hanson and I'm an associate in the family team at VWV. I will be chairing this debate today and I will shortly introduce you to my colleagues who you can see on screen who will be part of the debate. By way of reminder, today's debate will focus on the motion of whether parties should attend mediation to resolve their disputes, save for when there are genuine safeguarding concerns. I'm sure in your own practices, you will have had different experiences of mediation and different responses from clients when a suggestion of mediation is made. For some, it is a real opportunity to try and resolve their issues amicably, in a more cost-effective way and in order to avoid court proceedings. Some see mediation as a tick box exercise, which they simply have to do before they can issue court proceedings. Others may be open to the concept of mediation, but are so fearful of the process and how they may articulate those points in mediation that they do not feel that it is the right option for them. As most of you will be aware, the government have been actively considering whether mediation should be a mandatory step, save in limited circumstances. The answer to that question for now is no. However, we seem to be edging ever closer to that concept. It is important for us as practitioners to consider this question and the implication that this idea could have on our court system and on those that may or may not use it. From time to time, it is important for us all to challenge our own views and to consider whether other ideas may be persuasive. With this in mind, we are going to kick off with a vote. The motion I will be asking you to vote on is: separating couples should both be required to attempt mediation to resolve family issues, except where genuine safeguarding issues preclude it. Please vote for or against. Here we go. Right. So 78% are in favour of the motion. It's quite interesting. Okay. Well, this is good. I think this really gives an opportunity for one of you to really pull this back now. Okay. So I'd better introduce you to our panel then. So I'm delighted to be joined today by some exceptional lawyers, all of which are trained mediators. First, I'd like to welcome Stephen Wildblood KC from 3PB and Sam Hickman from VWV, who will be debating for and against the motion. For the avoidance of doubt, Sam and Stephen have both been given briefs to argue on either side of the motion. They will, of course, be fiercely fighting their corner. However, this may not necessarily reflect their own personal views. I will also be joined by our wonderful panel, which consists of Caroline Fell and Rebecca Eales from Stone King and Mary Gaskins from Burges Salmon. Our panel are here to answer your questions. Ahead of this webinar, we invited you to send us your questions, and we are so grateful for the responses that we've received. If at the end we have any more time, please feel free to add some questions to the chat as we go through, and we will see if we can answer those at the end. I'm very conscious that we've got a lot to get through today, so we'll try to stick very rigidly to the timetable. The debate will be as follows. So Stephen will be speaking for the first 10 minutes, followed by Sam for a further 10 minutes. We will then follow with the questions to the panel, and we've allowed around 30 minutes for this. Finally, we will ask you to vote again, and it'll be interesting to see whether anyone has changed their mind following what they've heard today. So enough from me. Stephen, would you like to kick us off?
Yes, thank you. And I'll see what I can do to lose the 78%. Delphine has very kindly agreed to show my slides. Thank you, Delphine. And we'll just wait while that is. Thank you very much indeed for joining the debate. So can we show the first slide, do you think, please, Delphine? Thank you. Those are my key arguments. So first of all, the workload of the court cannot continue to increase. The court's not coping. Second, everyone knows that mediation produces better outcomes. Third, the state has a legitimate interest in requiring parties to attempt mediation. Fourth, in my view, it's plain encouragement or simply giving information isn't enough and doesn't work. It hasn't worked. The MIAM hasn't worked. I'm not arguing that a mediated solution must be achieved. I am arguing that the process of mediation must be attempted. The fifth point is that other countries do require mediation, attempt at mediation before issuing. Also, in this country, in civil cases, parties may be required to attempt mediation. Why should that not apply in family cases? And last, we have a court-based culture. And I ask you to reflect on why. When couples separate, why is the first thing that they think about going to court? Delphine, could we see the next slide, please? I prepared this from statistics that are available on the internet from the MOJ. It shows the workload of the court. It compares it from 2014 on the right, 2023 on the left. I'd like you to pay particular attention, if you'd be so kind, as to the two bottom rows, because that is the area in which mediation can have its greater impact. Private law, children, couples splitting up, and financial remedy. Could we see the next slide, please? I've combined those, therefore. In 2014, the combination of private financial remedy and private law applications was 79,711 cases to the court. By 2023, that had gone up by 15,450, so to 95,161 applications. That's just financial remedy and private law. Private law delays in 2019 were 28.6 weeks and now 46 weeks in 2023. What's going to happen in 10 years' time by 2033 if that continues? Have you seen an enormous increase in the resources that are being put into the court estate and in the number of judges? I'd suggest not. Further, when considering the overall justice of the argument, I would ask you to bear in mind that in 2013, 41% of family cases saw a party with legal representation. By 2023, that was down to 19%, where both parties had legal representation. And also to recollect who is actually hearing these cases. More than 50% of cases involving private law disputes are now being heard by magistrates, who I would suggest are operating at absolutely maximum capacity. Could we see the next slide, please? Why do I say mediation produces better outcomes? Well, I think this is pretty obvious. First of all, mediation reflects and encourages autonomy and responsibility. The couple own their disputes and sort them out themselves. The result is an avoidance of adversarial litigation. We talk about quasi-adversarial or quasi-inquisitorial systems. It's not at all. A system is either adversarial or it's inquisitorial. Our system is essentially adversarial. If a case goes to court, it fights. It also avoids, mediation also avoids what I call the quasi-mediation of the court system. Attending at an FHDRA or a DRA or an FDR in front of a judge who very often is not a qualified mediator. It's not mediation. It's a different phenomenon altogether. Mediation is issue-led. It can be child-inclusive. How many times have children been seen by judges? And it is also welfare-compatible. My next argument is that mediation can be properly supported by funding if we choose. The voucher system has begun to have an impact, and I set out the figures in that paragraph. There's going to have been a fairly substantial investment by March 2025 of 23.6 million in it. Finally, we have already a full contingent of mediators, and I have no doubt at all that if mediation were to become compulsory, there would be a sufficient army of mediators to do the work. Why? Because people would start doing training to be mediators. If there weren't enough when it became compulsory, there would be more mediators. People would train to do the job. Could I see the next slide, please? Finally, on this point, court isn't free. We think of court expense by reference to the amount that parties pay to go to court. And so I thought it was helpful to put before you the figures from the legal aid budget. So you can compare first the legal aid closed cases and secondly, the expenditure. These figures compare October to December 2023 with the same period of 3 months the year before in 2022. There is a considerable expenditure within legal aid on family work, and that is borne from the public purse. Could we see the next slide, please, Delphine? And also, there are hidden costs. People like me, judiciary, they have to be paid for. HMCTS, the buildings, CAFCAS. It isn't just cost to the parties. And one of the problems I would suggest about the court system is, for some, they pay the application fee, £230, private law, 237 financial remedy work, and then they're in it for as long as it takes. And I would suggest that that explains some of the long-running cases that we see where people have no incentive to stop the case from running once they are locked into conflict, and the system allows them to be so. Next slide, please. So the MIAM encouragement, it was introduced in April 2011. 6 years later, you'll see what the NFM said, that 6 out of 10 couples were ignoring the need for a MIAM. If people want to find a way around the MIAM, as it is at the moment, they will do, and they do. And they do that and go as a means of getting into the court system, because the court system is not strong enough, I'd suggest, to boot them back into mediation. There are new rules, I recognise that. And what I say about that is this. If because of the obvious benefits of mediation, the court can adjourn to encourage mediation and can in some cases impose cost sanctions for not mediating, why not take the further step and require mediation? If mediation is so good, make it a requirement. Thank you. Could I see the next slide, please? I've referred to the case of Churchill and Merthyr Tydfil. That is the case in which it was established that in civil cases, the court can require parties to engage in mediation. Cases can be adjourned on the basis that the parties are required to mediate. That was a strong step forward by the Court of Appeal. Could I look at the next slide, please? This is the nearest you get in family cases, where Mrs. Justice Knowles refers to the case of Churchill and the new rules, and says that it may be unwise to assume that Churchill is of limited relevance to family proceedings. But what nobody can say is that in family cases, at the moment, the court can insist on mediation like in civil. And this case does not go that far. And finally, I think this is my last slide and my time is up. Why is court best? Please ask yourself why. Why hint at or express the benefits of mediation, but not have it as an ingrained requirement. Other countries do. 12 states in the United States, Norway, Belgium to an extent, Australia under their 1975 Act, they all have a requirement for mediation before people can come to court. And the last point I make is a requirement of attempted mediation is not a denial of right. If the parties cannot mediate, then of course they can come to court, but they must be forced to attempt it, in my view. Thank you.
Thank you, Stephen. That was a very comprehensive explanation as to why mediation should be mandatory. I think that the fact that the pressures that are on the court, that surely we need to do something about that. Right, so next, Sam. Got 78% of people to try and persuade.
Thank you, Katie. I'll be presenting the arguments against the motion today. Could I have the next slide, please, Delphine? By way of introduction, the key points I will be covering are the government consultation, key principles of mediation, could the system cope with mandatory mediation, and why compulsory mediation will not work. Stephen has already talked about the eye-watering delays, and I'm sure many of us will have experienced hearings vacated at the 11th hour due to judicial unavailability and cases transferred out to overflow courts. Should there be any doubt, the family court system in England and Wales is on its knees. It's not surprising, therefore, that both the government and the judiciary are keen to use mediation to filter out cases from a court system that is increasingly not fit for purpose. On the surface, it's easy to see how one could naively jump to the conclusion that the panacea is to force couples to attend compulsory mediation. But this raises a number of significant concerns that undermine the very ethos of mediation. I want to explore some of those today. Could I have the next slide, Delphine, please? Thank you. Everyone will be aware that in March 2023, the government launched a consultation on resolving private family disputes earlier through family mediation. One of the significant changes proposed was the introduction of a requirement to make a reasonable attempt at mediation before issuing proceedings unless an exemption applied. The ethos behind the government's proposal was largely uncontentious, namely a commitment to, and I quote, focus on earlier support for families before conflict between them becomes entrenched, and allowing court resources to be reserved for the families and children who are most in need of the court's involvement and protection. Next slide, please, Delphine. Amongst the statistics contained in the consultation were the fact that the average length of time for private law children cases had risen from 26.1 weeks in 2015 to 45 weeks in September 2022. By June 2023, the average time for determining applications had increased to 47 weeks. It was further recognised in the consultation that this increase creates prolonged uncertainty for both adults and children and is therefore potentially harmful for families. Government support of family mediation as a process that is quicker, cheaper and more constructive is very welcome. Alongside this, the consultation recognised that mediation works with an impressive 69% success rate. The Family Mediation Voucher Scheme has made it possible for over 13,500 families to enlist the help of mediators and reach full or partial agreements, without the need to go through a potentially long and adversarial court process. I took no issue with the government's intent. After all, the aim was to direct people into a process that is faster and better for all concerned and has a good chance of success. So, what's not to like? Both Resolution and the Law Society submitted responses to the consultation, as neither organisation supported a requirement for pre-court mediation. There are various areas of contention. To start with, mediation is not a panacea, and there are some cases where it will not be effective or appropriate. In particular, where there are allegations of domestic abuse, but also issues around controlling behaviour or other safeguarding concerns. Mediation may be entirely unsuitable for these cases, and the court's assistance may be required. Next slide, please. One of the core principles of family mediation is that it is a voluntary process. To suggest it should be compulsory demonstrates a lack of awareness about how the process works and fails to recognise that compulsion is likely to achieve the opposite effect of what is intended. The fact mediation is a voluntary process is not just something that mediators pay lip service to. It's something that mediators hold very close to their hearts. Mediators want to be working with families that want to be attending family mediation. That's not to say that everyone wants to meet a mediator, but most people recognise the value of trying to have constructive conversations as a starting point to settling a dispute. Mediators will often hear one or both parties say that the other side is not taking it seriously or is not here to negotiate. But in my experience, that's rarely true. Even if parties are somewhat half-hearted at the beginning of the day, the process takes over and creates its own momentum. As a mediator, the fact that mediation is voluntary is a platform I can rely upon within the mediation process. Mediators will often reinforce this message by stating something along the lines of, "Neither of you have to be here. You've chosen to be here. Hopefully that's because you both recognise that there are significant benefits to you of being able to sort this out together." I'm not sure that the message, "Both of you have to be here before you can make an application to the court," has the same ring to it. Next slide, please, Delphine. The other potential difficulty with the proposals made in the consultation was the suggestion that mediators will need to provide a certificate to court confirming that people have made a reasonable attempt at mediation. Again, this sits against a core principle of mediation, namely the impartiality of the mediator. This is another principle that is fundamental to how we operate as mediators. Without this, how do we engender trust? A mediator's role is not to judge in any way. Under a system of mandatory mediation, that would change, and instead, mediators will find themselves saying, "I'm not here to judge you in any way, except to keep note of whether I think you're engaging in a reasonable attempt at mediation." This is completely subjective and open to interpretation. It is definitely not a statement I really want to be making as a mediator. Next slide, please, Delphine. A further consequence of introducing mandatory mediation is that it's likely that more people will be accessing services. Whilst this is a positive, and the indication is that the profession does have capacity to respond to this increased demand, an unintended consequence could well be that less and less services will offer legal aid for family mediation due to rates for mediators remaining static for years. Other forms of dispute resolution, such as collaborative law, roundtable negotiations, arbitration, and private FDRs, may be more appropriate than mediation in certain cases, and may be overlooked or not given due consideration if mediation is made mandatory. The government have, of course, shelved plans for mandatory mediation, citing concerns about the adequacy of proposed safeguards to protect victims of domestic abuse. The MOJ will instead work with the Family Mediation Council to improve training for mediators on abuse and identifying victims. Next slide, please, Delphine. In addition, in April this year, important revisions were made to the family procedure rules, in particular parts 3 and 28, which apply to both financial remedy and private law children cases. I won't go through those in detail today due to time constraints, but the court will now be encouraging parties to consider non-court dispute resolution at every stage of the process. The definition of non-court dispute resolution is also widened to encompass not just mediation, but other methods of resolving disputes other than through the court process, including mediation, especially child-inclusive mediation, arbitration, evaluation by a neutral third party, such as private FDRs, collaborative law, and the one lawyer, two clients model, such as resolution together. There's a vast array of options. Early advice is very different to mandatory mediation. The government has clearly listened to concerns and implemented policies which will help families seeking justice. There is no one-size-fits-all, and there has been recognition of the fact that mandatory attendance at mediation could negatively affect the outcome of a dispute. Making mediation voluntary means that domestic abuse victims can be referred to services that can guide them through the right dispute resolution process for them. Next slide, please, Delphine. In summary, overall, the government's plans are encouraging, but this U-turn demonstrates the need for a coordinated approach. This must involve the government, the judiciary, family lawyers, mediators, and everyone involved in the family justice system. Lawyers also need more training in how relationships work, why they break down, and how best to help clients when they do. And they need to show more awareness and encourage far greater use of all dispute resolution options. Thank you.
That's great. Thank you very much, Sam. I think it's really important that you've identified that perhaps mediation isn't suitable for everyone, and actually that you've identified the underlying principles of mediation, which potentially could be effective if it's made compulsory. So next thing then, we're going to move on to some questions to our panel, so Caroline, Mary and Rebecca. So first question I want to start off with then is, someone has written into us to say, I'd like to ask the panel's views on how compulsory mediation can ensure the emotional health of families and professionals to better transform conflict at a deep and enduring level. And I think, Mary, you volunteered to answer this question.
Thank you, Katie, and good afternoon, everyone. This is a fantastic question, and I'm going to break it down as it actually covers quite a lot. And I'm also, for the purpose of this answer, assuming that there's no genuine safeguarding issues precluding the mediation process from taking place. So the question asks about families and professionals and their emotional health and transforming conflict. Looking at this question in relation to families, we can break this down to children mediations and financial mediation separately. In mediations relating to children arrangements, the emotional health of the family and addressing the conflict that is likely to be present is absolutely fundamental. The mediation process is working towards creating a foundation where parents are able to communicate and listen to one another. As the clients in a children mediation process will continue to be linked through the virtue of being parents for, or essentially forever, they will need to be equipped with the ability to communicate and deal with tricky issues that are inevitably going to crop up in the future and couldn't necessarily be predicted at the point of mediation or another process. I firmly believe that mediation done by a family law trained mediator can help to embed a better family relationship and provide them with the tools to deal with the future. it can also enable the parents to work out their own solutions and take over control about how they're going to parent. Any decision that is made by them together is going to have a far better chance of success than having a decision imposed on them by a court. Mediation provides a space for clients to share proposals and also to reality test them. This is absolutely crucial in ensuring that the cooperation endures beyond the mediation process. In relation to the mediation cases aimed at reaching a financial settlement, it's important to emphasise that mediation as a process does not mean that no one else is involved. Most clients have their own solicitor providing advice in the background, but it provides a forum for clients to feel heard and have their feelings acknowledged by the other person. From my experience, the impact that this can have on resolving a point of conflict or moving something forward is profound. Often, without the mediation forum, these issues are then dealt with through solicitors' correspondence or in court and can only exasperate and entrench positions and obviously increase conflict. By helping clients to be able to listen to one another and communicate directly, this means that it can be extremely effective and efficient, which can reduce costs. So again, that impacts on the health of families and also impact the final outcome in a case. As they often have a solicitor in the background, if they need individual advice, they can access that. And if an agreement can't be reached on a specific issue, and this applies to children mediations as well, then an early neutral evaluation could be sought in order to try to resolve it and move forward. In terms of more complex financial cases, mediation is extremely flexible in terms of involving third parties. For example, you can bring in a single joint expert in relation to pensions or business valuation. So it can be really, really flexible and kind of meet the needs of the clients. It's also important to note that us as mediators, we don't just allow the process to go on, and the right mediator will be managing that process actively and ensuring there isn't any unnecessary delay between those sessions, and also ensuring that sessions are continuing to be effective and also constructive, and that they continue to meet safeguarding rules. So if at any point I felt that a mediation is falling short in any of these aspects, then an assessment would need to be made, and to ensure that the case was not continuing when it shouldn't be, which obviously is important in looking at the health of families and the clients in mediation. At that point, they potentially would need to find an alternative route. Sorry, I think that's quite a long answer, but it's quite a long question. I wanted to make sure I dealt with each point.
No, I'm sure everyone's very grateful for the level of detail you went into there, Mary. Thank you very much. So the next question then, I'm looking at Caroline, is if mediation was compulsory, how would you get around the concern, therefore, that any settlement agreement resulting from compulsory mediation was not then caught up by undue influence and not entered into freely?
Thank you very much, Katie. Yes, it's a really legitimate concern. And I'd start off by saying that compulsory mediation, one would still have the MIAM at the outset to identify any safeguarding concerns. Safeguarding undue influence, it's a difficult one potentially to identify. Somebody may be more prepared to discuss concerns surrounding domestic abuse, but influence may perhaps be more difficult to pick up on at a MIAM. But that is certainly something which we look to do in the MIAM to try to understand the dynamics between the parties and to make sure that that there aren't any genuine safeguarding concerns which may mean that mediation isn't appropriate. It is the role of the mediator to try to assist in levelling the playing field between parties. It's very rare that a couple come into mediation on exactly the same plane. We're there to assist in looking at proposals together, reality testing those proposals, to ensure that each client has a full understanding of the consequences for them of any agreement entered into. And that reduces risks in relation to undue influence if one picks apart what is being proposed and discussed and looks at it, looks at each aspect. I think that helps to ensure that that any influence which is being exercised and one perhaps isn't aware of is broken down. The important aspect, though, however, is that as Mary said, mediation isn't in isolation, and we always encourage and support clients in obtaining legal advice as part of the process. And we would particularly flag that up if there was any inkling of undue influence, or indeed of that playing field being not as level as one might like. And we may also look to suggest a hybrid model involving solicitors within the process where such concerns arise. And remember that any proposals which are reached by the parties remain without prejudice, and it's not until the parties have had the benefit of legal advice and the agreement is drawn up formally that it becomes binding on them. And therefore, again, hopefully that ensures protection against one party being unduly influenced by the other. So I think that covers that question, Katie.
That's great. Thank you very much, Caroline. So the next question then, this is actually one, it's a very good question, actually one that I have to talk about quite often in practice. And this is whether mediation is suitable if there are no safeguarding concerns, but there is a significant power imbalance between the parties. How can this be addressed? And, you know, is hybrid mediation an option in order to address that?
Thank you,
And
Katie.
that's to Rebecca.
Thank you, Katie. These questions are all brilliant, actually. They're all fantastic questions. And actually, this question leads in quite nicely from the undue influence question that Caroline's just answered. The MIAM is such a crucial part of the mediation process. Mediators know that the MIAM is not just some sort of like finding out and just telling you what mediation's about. It is so, so crucial in being able to understand from the parties, you know, are there any safeguarding concerns? But if there aren't, even if there aren't, they need to understand if there are going to be issues as to power imbalance. You know, they could be issues such as coercive and controlling behaviour. They could be issues where one person has a significant financial lack of knowledge. There could be somebody who feels that they are in a situation where they have no option but to say yes to something because of financial imbalance in a relationship. It could also be that if they know that the court has made them come back and they feel they have no choice, otherwise the court can make decisions they don't like. Again, that could be a power imbalance. So the key in the MIAM is to actually really explore that. And mediators, we ask lots and lots of questions in our MIAMs to really understand about that power imbalance, because it's key that one of the real key principles of mediation is that everybody has to be on the same level playing field. There can't be any power imbalance, because if you have any power imbalance, then actually is mediation going to work? So the first thing is to be able to look at what is that power imbalance that exists? What is it? Then thinking, okay, are we going to need to take specific steps to ensure that the participants are on equal footings? And that might not necessarily be just saying, oh, well, we could do it in shuttle, so that will make it safe. Because you cannot guarantee that just even having the parties in a shuttle mediation process will make it safe for them and will address that power imbalance. So it's so important that during that MIAM process, that clients are able to explore how things have been in their relationship, what concerns them. One of the things I often see as a mediator is one party who will say, I just know nothing about the finances. I know nothing at all. They controlled all the finances. I know nothing. And it's really important then that if mediation does go ahead, that the mediator, we think about very carefully, what are those specific steps that we would need to do so that everybody is on an equal footing. And that may be that we do have to spend time in flip charting the information, using spreadsheets, and of course then referring clients back regularly to their solicitors if they're concerned about things. I think the other key thing that ties into this is that mediation isn't for everybody. And the real key part of the MIAM is to also explore at length other non-court dispute resolution processes that are available to clients. Because, you know, I'm a lawyer and a mediator, and I think the mediation is fantastic, but it isn't for everybody. You know, there can be clients who actually would not feel comfortable doing mediation, even if we had a hybrid approach. And it may well be that a collaborative approach would be right for them, or one of the other non-court dispute resolution processes that Sam's spoken about this afternoon. If we assess and we think it's not appropriate, it doesn't necessarily mean just because it's not appropriate now that it might not be appropriate moving forward. It may well be that couples, if there is a concern about being able to understand the financial disclosure, that they could come back to mediation when they've narrowed issues. So it's not it's not going to work now, so it's never going to work. And therefore, the mediators, if a mediator assesses it's not going to be suitable, they're going to say something like, we don't feel that mediation will be a helpful and suitable process at the moment. That's given the message to the participants that it is clear that there's been no judgment made by the mediator, and it's clear that if they want to come back at any stage and try again, they can. Thank you.
Right, thank you very much, Rebecca. Mary, I'm going to come back to you for this next question. How will we promote judicial encouragement for parties to attend mediation?
Thanks, Katie. I will answer briefly, and then I'm going to ask for Stephen's thoughts, if that's okay. But my view here is that as family law professionals, we need to be aligned with the judiciary in order for us to be able to advise clients that they need to actively engage in mediation, and this is obviously with my solicitor hat on, or other non-court dispute resolution options. We need the judges to enforce this. Judges shouldn't be afraid to send parties away if they have not complied with the rules, and this in turn will pass on a clear message that the rules cannot be ignored. Whilst I appreciate this has to be carefully balanced with progressing a case and proportionality, surely a firm approach must be taken in order for the rules to gain traction. And Stephen, I wondered if you had any additional comments on that question.
I think it's the most important thing is education, ensuring that judges are properly educated as to what mediation is. And the benefits of it. I think already judges are very aware that they are under enormous pressure within the court. But I do think that there needs to be more understanding about the process of mediation and what it can and cannot achieve.
Can I just add something there as well? It's interesting, just on the ground, I think we're finding as mediators that judges are wanting to use the child inclusive mediation practice as Kafka's report, welfare reports by the back door, wishes and feelings reports by the back door. And that it's education, I think, Stephen, about how and where mediation can assist, and where perhaps it can't be used within the judicial process itself. So it will be interesting as the new rules unfold, how we can support the judiciary in understanding where mediation can help and where it can't. Yes,
I don't think that mediation can be used as a means of obviating the getting around the role of Kafkas, or of obtaining reports about a child's wishes and feelings. I think I'd be sorry to see mediation being used in that way. I'm not so sure about mediation taking place within the judicial process. I don't see why it can't. I mean, that's exactly what is happening in civil following Churchill, that you can stop a civil case and tell the parties you are going to go for mediation. And how many cases have we all seen, I wonder, where the parties are simply locked into conflict, coming back to court again and again, £1 million in one case on legal fees, where the issue was the quantum of contact, £17,500 a month, the cost allowance for a mother, in another case where the issue was how much time the children should spend with the father and which school the two children should go to. And instead of the court being able to say, I'm not going to listen to this, you're going to have to go to address these, because after a judge has reached a decision, you've still got to behave as parents, you've still got to liaise with each other. The judge's decision is not the end of the road. You've got years and years to come of parental responsibility. And so I do think that it's about time the family court was able to behave as the civil court now can, and has been happening in Australia since the 1975 Act then.
Rebecca, I think you had your hand up.
And I did, because I think we have seen, us practitioners have seen actually an increase in the amount of clients who are coming to us because courts at the gatekeeping stage are pushing clients to mediation. And they are coming to mediation, they are coming to their MIAMs, and it's interesting, they have this perception that they're being made to do it. And so obviously we as mediators have to spend some time talking about the voluntary and the principles, etc. But interestingly, that court door approach almost that we does make them work much harder, I've noticed, to really try to want to come to resolution. They really, because they know that there is a backdrop of a hearing that might be happening in a month, 6 weeks' time, and they know that if they don't reach decision, that the court could make a decision they don't like, they do work that much harder in really trying to come to decisions, because they know the alternative could be something that neither of them want and could not necessarily be in the best interest of their children. And to me, a successful mediation as well, I know we're getting off the subject slightly, is that, and I think that it's not just about the parents agreeing that one niche issue that the court might have referred them back for that led to them making that application, but it's actually about them working together and having strategies so that if the wheels fall off again, they not going to go running back to the court again. And I think that if there's some education amongst lawyers, judiciary, etc., that actually that really can help. But then hopefully that's going to encourage people to come to mediation more. I slightly sidetracked that, but I thought it was a useful aside.
No, very useful, and thank you for all of your input on that question. So I think the next question then is, should collaborative law be available as an alternative to prescribed mediation? Rebecca.
That's an interesting one. No, that's fine. It's a really interesting one, because I think lots of us here actually involved were collaborative lawyers and family mediators as well. And it's horses for courses. Not everybody is right for mediation, just as not everybody is right for collaborative work. And I think that one of the key things we do need to think about with collaborative law is that it is very expensive. You know, we know when we've done collaborative work, those costs do increase substantially. And that I do believe that it is an alternative to mediation, just like other non-court dispute resolution processes are an alternative. And we as mediators will talk about collaborative law in our MIAM. When I do a MIAM with clients, I will talk to them at length about how mediation is just one of the processes that's available for them to try to resolve issues amicably. And that although they may well be here to find out about mediation, that actually there may be other processes that are more suitable for them. And I think the MIAM is an important opportunity then to signpost those clients who may well have come to mediation and I don't know, their solicitor might have said, just go along and get a certificate. Now, mediators that are obliged to sit and talk with their clients and tell them about other non-court based resolution that they can use. And it isn't just about coming, tick box, getting your MIAM. It is about saying, okay, well, if mediation is not right for you and you feel that that's not a right process for you, what other processes do you feel that it would be right for you? Have you thought about collaborative law? This is how this works. And signposting clients off so they can find out more information about that. And it's actually the mediator's responsibility to provide that information in the MIAM and to indicate to clients what form of non-court DR process they think would be helpful to them and why. It's interesting that when the Family Mediation Council sent a note to all mediators upon the introduction of the new FPR rules in terms of non-court DR processes at the only a couple of weeks ago, the Family Mediation Council actually said, we don't need to at this stage we don't feel we need to change the MIAM standards, because embodied in the MIAM standards is the requirement for mediators to talk about those non-court dispute resolution processes anyway, and that's what they have been doing, which of course is, as we all know, not just mediation, but also collaborative law and the others that Sam has spoken about this afternoon as well. I hope that helps answer that question.
Thank you, Rebecca. Next question then, Caroline. I'm looking at you for this one. And actually, I really like this question because it's very practical. So what are the pre-mediation conversations that need to have been had with your opponent to make mediation more successful? What are the tips for preparing for mediation? And how do we condition our clients so that mediation is neither too oppressive or a squandered opportunity?
Yeah, it's a really good question. My personal view is that mediation has the greatest chance of success if the client is well supported by a sensible solicitor. Legal advice is, to my mind, complementary to the mediation process, and mediation isn't a replacement for getting legal advice. They sit alongside each other very comfortably. As a solicitor, if I were to discuss mediation with them and the benefits to them of mediation, I would encourage the client to go in with an open mind, to discuss the fact that it's an opportunity to enable issues arising on separation to be resolved together with support, and enable a co-parenting relationship to endure beyond the separation process. They can explain to the client that it's not a soft option. There are still requirements for financial disclosure, for example, but that you're also there as their solicitor for them to discuss matters between sessions should they wish. That when a client comes to you to ask what you would consider the outcome to be in the event of a court application being made, that you provide a realistic range of outcomes, rather than best case scenarios. I'm sure that that's the case on the ground, but it really helps if one explains to a client that actually court is hugely uncertain. There are no guarantees as to outcome, and actually on a good day you may succeed in achieving your aims, but on a bad day not so much. So having that range is hugely helpful and really helps us within the mediation process. I'm very conscious of time because I know that there are some other questions popping up on the Q&A, so I'll leave that one there so that we've got a little bit of time for additional questions before we do the final poll.
Yeah, no problem. Right, I will just run through this question. Helpfully comes with some background as well, so apologies, I'm going to be reading off my screen for this. So the background to this question then is we use a variety of mediation services, and I have to say that clients sometimes respond to mediation negatively, particularly some clients who are victims of abuse but want to try and narrow issues, so give mediation a go, and often feel sadly mediators do not intervene when the perpetrator tries to exert control, etc., and hence feel a lot of the time that they've been unsupported and the mediation has been unsuccessful. So the question then is, how can we assure across the board that mediators are delivering the same approach when dealing with clients? Would there be additional training delivered, or would there in due course be a suggested code of practice for mediators to comply with to ensure some consistency? Does anyone feel able to answer that? Rebecca?
Thanks, Katie. It's a really good question, actually, because it is something that we hear as solicitors as well, that we can have some clients that have gone to mediation services where they've really felt it's gone fantastically, and others have felt that as well. And I think that's where the key thing of the MIAM comes in. It's so important that that screening happens, and those clients need to be supported so they can talk about those concerns. And are there trigger words? Are there trigger of things that might come up that are going to make them feel like that, so that mediator's alive? I think in terms of the training, I mean, all mediators have to do a certain amount of training every single year. And it may well be that it's something for the Family Mediation Council to think about and say, actually, there are some mediators who may well have trained a while ago. Is it time, with the way that mediation's moving on now and the way that courts are referring clients and saying to clients, you know, go on, give mediation a go. You know, we see that really, really regularly in our practice, where as a result of the safeguarding letter, the Kafka's office has mooted it with them and they've gone, oh, okay. And then gatekeeping, the court sends them to mediation. And I think that there does need to be some sort of training to make sure that people do understand that. And that's the key skill for the mediator, to be able to manage that process so that people feel that they are being heard and they are working together to reach resolution. But by also remembering that mediators have to be impartial, and it is a skill. It's a skill to be able to ensure that you don't let one person have the floor for too long and feel that the other person feels they're being dominated. And I think I would suggest the one thing for your clients is to make sure that if your clients are feeling that they want to give it a go, but there are massive concerns about them, they do talk to the mediator about how things have been, you know, when there were arguments when they were married, how did they end up being resolved? Who made the decisions for things like going on holiday, or what school the children should go to, those sorts of decisions. And that's going to enable the mediator to make actually quite a good judgment as well as to whether mediation is appropriate or not, because it may well be that it's not.
That's great. Thank you very much, Rebecca. Well, I think we've sort of come to our end of our half an hour allocated time. So thank you everyone that's put forward questions, and also those that have answered them. Thank you very much to our panel, and also Stephen for your view from the judiciary. I think now is the time to do another vote, to actually see whether anyone has changed their mind, having now listened to everything that we've had to say. So I'll give you sort of 30 seconds or so to cast your vote. All right, here we go. 70-30, so 70% for, 30% against. So yeah, so move slightly. So no, that's interesting, and I'm pleased that people went into this with an open mind. I think, as I said at the start, because I think we do have our views, and actually training sessions like this are great in terms of challenging those views, keeping an open mind, etc. So I think that brings us to the end of our session today. So thank you very much everyone for listening, and I think we've kept the attention of most people, so that's great. Thank you very much Stephen and Sam for your comments, and also to our panel for your input in answering the questions. So thank you very much everyone.